If I don't like the case, I won't take it. And if counsel hasn't been upfront with me from the beginning, and all of a sudden in the middle of things, I find stuff that, we got a serious problem. I'm on the phone immediately to counsel and say, we got a problem here. And I have actually had to withdraw from cases because of it.
How the role of an expert has changed, or has it changed at all? Like, are juries more or less receptive to expert testimony today than they were when you started?
But I really think the role of an expert, number one, is to be as neutral as possible. I really don't care whether the plaintiff wins or the defense wins. I care about what's true.
Hello and welcome back to a brand new episode of On the Stand with Ashish Arun. Today we have a true industry legend, someone who's been called many things over his 50-year career, but perhaps the most memorable is the coverage terrorist. Frederick Fisher is not your typical expert witness. He's a force of nature in the insurance and professional liability world. A founding member and past president of the Professional Liability Underwriting Society, the 2019 recipient of the prestigious Plus Founders Award, and the author of the definitive book on claims-made insurance policies. He started his career in the 1970s as a professional liability claims adjuster, spent 20 years managing complex claims, founded his own TPA, and then built ELM insurance brokers from scratch into a $30 million wholesale brokerage. Along the way, he's testified in well over 50 depositions and more than 25 trials, worked on over 300 cases, and has been retained equally by plaintiffs and defendants, a balance he deliberately maintains to preserve his objectivity. He's authored over 80 articles, delivered more than 175 presentations and CE courses, and serves as the Senior Technical Advisor for the International Risk Management Institute's Professional Liability Manual, a role he's held since 1990. His recent book, Claims Made Insurance, The Policy That Changed the Industry, is considered essential reading for anyone in professional liability. But what makes Fred truly unique is his philosophy. As he puts it, insurance should be a safety net, not a trap. He spent his career warning clients about what he calls the gotchas that will get you. So we'll definitely ask him about that and those hidden policy traps and misaligned assumptions that devastate policyholders. So on that note, let's welcome Fred on the stand. Fred, welcome to the show.
Well, good morning, sir, and thank you
Good
so
morning.
much for having me. And
pleasure
just
is
for
all
the
mine.
record, I got to tell you, you certainly have researched my background significantly, and I'm very impressed with that. That you're more prepared than anybody that ever has interviewed me recently. I'm very impressed.
No, that's a standard that we have to meet, because one of our core bread and butter businesses is researching the background of expert witnesses. So thank you so much for noticing that and appreciating that. Let me ask you about your career that spans claim adjusting, TPA ownership, wholesale brokerage, and now expert witness work. So please walk us through how you got started in the 70s and what drew you to the professional liability specifically.
Oh, good Lord. It was by accident, literally by
Okay.
accident. I was going to be an entertainment lawyer. And of
Mhm.
course, the only thing you can look forward to when you graduate from college with a social science field major is to sell life insurance, which was true. I ended up doing that for the first 6 months and hated it. But I had elected to apply and got accepted to go to law school at night. And I did that intentionally because I wasn't so arrogant as to think number one, that if I got into Stanford or Bolt or Hastings or one of the big name law schools, I wasn't so arrogant as to think I would graduate in the top 10% of the class. And they were the only ones that had jobs waiting for them because it was a pretty tight market back then. On the other hand, for those students that were going to night law schools and working in the legal industry during the day, they had a job waiting for them when they graduated, especially if they passed the bar. And I figured I like those ads. I like those ads. So that was the idea. And I was desperately trying to get into the legal community while I was going to school. And after 2.5 years, I finally did. And ended up as a law clerk for first an insurance defense firm.
Mhm.
And I did that for about a year, but that's not what happened. I got laid off from that job because the senior partner finally decided I need a young lawyer that can do Fisher's job and also go to polling. So I got laid off, and that did me a huge favor. Meanwhile, I had a friend who was working for this claim adjusting firm, and she got me an interview. And because I had law firm experience and had a year and a half left to go to law school at night, they figured, oh boy, another hard worker we could pay cheap and get a hard worker. And they did nothing but professional liability claims. I had no idea that sort of thing was going on. I was a law clerk. I was involved with slip and falls and car accidents and product liability cases, pretty what I considered fairly standard stuff. This was a whole new world. Every single claim was different. You didn't know whether you, with a lawyer, if you were dealing with something simple like blowing a statute of limitations, or some nitwit that decided to be a mediator without declaring himself as such between a husband and a wife who wanted a divorce, and they'd worked it all out, and all they wanted to do is make it legal, and then he gets sued by both for conflict of interest. Go figure. And here with a third-year law student, I get to walk into his office and look at him and think, "Gosh, what were you thinking when you did that?" But I was good at it, and the clients liked us, and we were boots on the ground investigators, and our goal was to factually develop that claim in 90 days or less and assess it. And of course, we had to give interim reports to the insurance company. And then we were also dealing with something relatively brand new called a claims-made insurance policy. It was like, whoa, what is that? And it took me a good 3 or 4 months to really get a handle on the nuances of it. And it wasn't even as complicated then as it is today, because it was relatively new in 1975. So one thing led to another. When I graduated law school, I had 11 job offers from law firms, 11. And it was like mission accomplished. The problem was I knew that if I took one of those jobs, I'd be a young associate. I probably wouldn't even be allowed to take a deposition for 3 years. And meanwhile, Miller and Gilbert was the name of the firm I was working for, and they were also acting as a third-party administrator for some of the insurance company clients, which meant that we were not only investigating and developing the claims, we were also settling them within our authority. And we had the ability to hire counsel based on a pre-approved list. So I figured, well, they just opened up a Los Angeles office, and they offered me to be the manager. Which meant, well, let me get this straight. I could take a job at a law firm and take orders, or I could take the job in LA and give them. So that was a no-brainer. And I took the job, and eventually I ended up becoming a partner, and I ended up buying them out. And then up through 1994, I think, or 95, I expanded the company. We did not only the same thing, the main revenue source was boots on the ground investigation and claim development, claim management for insurance companies that allowed it. We also represented self-insureds for large companies that had huge deductibles. We developed our own in-house software. We did all sorts of stuff and a lot of qualitative claim auditing. And we did that for some pretty big organizations and made some recommendations that to me at the time seemed obvious, but you look at what's going on today, and we proved statistically and empirically that the claims department is a profit center. And unfortunately, people have forgotten that. They now treat it as a cost center, and it's not. And the model was changing rapidly. And so eventually I decided enough of this. And I got my broker licenses, and I was relatively high profile at the time already. I published articles. I was giving loss control seminars live seminars, because they didn't have the webinars back then. And teaching people how to avoid claims. I mean, you handle enough claims against real estate brokers and insurance brokers and law firms and whatever, you start seeing patterns, and you start saying to yourself, this was avoidable. Yeah. So I started giving, and I wasn't the first, I'll tell you. I started giving lectures and seminars and continuing education courses as that industry developed on how to prevent claims. My first book was in 1981. It was called Broker Beware, Selling Real Estate Within the Law. I was supposed to do one for insurance brokers, but I never got around to it. But I was giving a lot of seminars and webinars to insurance brokers, and still do, on how to prevent claims. What's better, successfully defending a lawsuit or not having one at all? And lawyers thought it was a good idea. So by the 1990s, they started calling it best practices. But I'm one of 4 people that invented it. I certainly wasn't the first. Donald Malecki was. He started writing a monthly article for the National Underwriter back in the days when that was a big deal. It was all in print back then. There was no internet. And he wrote a monthly column on this very topic, how to conduct yourself to prevent claims. And Kevin Quinley was right behind him a couple of years. And then I followed that. And then there was another fellow named Curtis Pearsall. So the 4 of us really were the ones that started doing this. And it caught on. I think Lawyers Mutual Insurance Company thought it was a good idea in the late 70s. And they did an in-house program for law firms. And it took off. And eventually, like I said, lawyers by the mid-1990s tried to steal the idea and call it best practices. So that's how that all happened. It was so addicting because the claims were fascinating, the policy forms were fascinating, and especially with insurance agent and law firms, you had a claim within a claim. Because, it's one thing to determine whether or not there was a breach of duty by an insurance broker or a lawyer or what have you. It's another thing to look at, okay, now what's damages? And you had to look at the underlying matter. And sometimes that could get pretty darn complicated. Whether it was a lawyer that blew a statute of limitations on an automobile case, okay, that one's easy. But what if he blew it on a merger, some merger stuff that happened? Now you got forensic accountants you're going to have to get involved. I mean, it was, those were complicated cases. And then we got involved in frauds, fraudulent behavior as well. I could spend a couple of days on that. But it was fascinating work. Every claim was different. But what was common for most of them was that all the policies we're dealing with were claims-made policies. So I was right there during its evolution. From, I think, the program with Equity General Agents for Cal Union. They were Equity General was a managing underwriter for Cal Union, and they wrote a lot of professional liability. It was all claims-made form. I still have a copy of it from circa 1972. And you got to see how the policy forms evolved. And as a result, I knew where the bad language was. I knew now that I now call them gotchas, it'll get you, which is currently, we've got preliminary approval for trademark, and we're waiting for the final. But I filed for that, for trademark status on that. And they just got more complicated over time. So it was addicting work, just addicting. That's how it happened, by accident.
Today's episode of On the Stand is brought to you by Xlightum, the AI-powered platform where attorneys find expert witnesses and experts grow their practice. Every week, hundreds of new experts join Xlightum, giving attorneys instant access to qualified witnesses without any finder's fee or markups. Need someone else to handle the vetting? Our concierge service does it all. You only pay when you retain an expert we present. So whether you are searching yourself or letting us do the heavy lifting, Xlightum makes expert discovery fast and smarter. Visit Xlightum, that's exlitem.com, to find your next expert witness today. So 20 years on the claim side, and then you transition to brokerage. So what made you want to switch? And have a follow-up to that. And what did that claims experience eventually become your secret weapon when you moved to brokerage?
Well, you could see it happening over time. Number one, all of a sudden I had competitors. Now, the fact that I had 20 years experience by the early 1990s, did that make me any better than somebody with 10? I don't know. So you had more competition. But the other problem was the marketplace was shrinking because more and more insurance companies followed the lead that, and again, I wasn't the first. I was a recipient of it. But we hired nothing but people with law degrees. We didn't require that they had passed the bar, but we wanted people that were either in law school or had law degrees, much like Miller and Gilbert did when they hired me. And the reason being, when you're handling cases against lawyers and what have you, you got to know what the law is. More importantly, what the standard of care is. And be able to preserve evidence properly. I mean, we had a whole ritual with respect to recorded statements and how you handled them. So there was no question the statement was complete. There was no interruptions. Nothing was discussed without the tape recorder being on, that sort of thing. And so we couldn't be challenged on them, so to speak. And so we had all these background requirements. Insurance companies thought that was a good idea, so they started hiring lawyers for their claim departments. The problem was they were litigators. And, we were claim people with legal backgrounds. And there is a different mindset. We're interested in evaluating the claim, investigating the claim, and then deciding what's the best solution. You start putting defense law, you start hiring litigating attorneys. And again, this is a little bit of an overgeneralization, but for the most part, the mentality of a litigator is, quote, make me. Make me. And that doesn't close files. That doesn't settle cases. That's number one. Number two, more and more claim departments weren't referring out to boots on the field investigators for one reason or another, which means they were hiring defense counsel to develop the claim. And there's a huge difference there, and we're seeing it now on a big scale. And that is, we could fully investigate the facts in 90 days or less, to the extent we could. Sometimes we'd have the cooperation of the claimant attorney, sometimes we didn't. But at least we had the vast majority of obtainable facts and evidence within 90 days or less, which means the reserves were set more accurately and earlier. And of course, you had a pretty good handle on what the case might be worth and what could happen with it. Is it defensible? Is it questionable? What have you? What's the approach to take care? Well, when you send everything to defense counsel, I got news for you. You can't get a scheduling order from them in 90 days. Number two, once you enter into discovery, and again, I don't want to paint an overly broad generalization, but discovery doesn't develop the claim. It develops admissible evidence. And there's a difference, because everybody's doing their best to live up to the standard and giving the minimum answer that is required without giving up everything, if possible, which is absurd. That prolongs litigation. It doesn't resolve it. And of course, chances are you might even be under reserved, because you really don't know what's going to happen or could happen, even though the purpose of discovery is to prevent surprises. But you'd be surprised how often that happens anyway. But so the whole approach was different. And I could see the writing on the wall. So like I said, I'd already given a lot of speeches and written articles. I was a senior technical advisor on the professional liability for IRMI, the International Risk Management Institute. And I was on the board of Plus. And I finally decided, screw it. I'm going to open up a wholesale insurance brokerage, because I knew enough retail brokers from my claim days. And I figured, you know what? If I could get 30 or 40 brokers using me, maybe up to a couple of hundred, and sending me just one piece of business a year, just one, I'm going to be really busy. I'm going to do okay. Went beyond my wildest expectation. It just exploded. The timing couldn't have been better. Smaller insurance agencies wouldn't get serviced by the big boys. The bigger wholesalers didn't want to waste their time on small accounts. I didn't care. I'd take anything. And of course, we did something that most people wouldn't do. I came from the claim side, the professional liability claim side. Yeah. I was all about claim prevention. So the idea was, we are going to support our brokers. We are going to help them. We're going to guide them. We're going to give them the advice they need to hear. We would have conference calls with them and their client to explain the coverage problems or coverage issues. We did something nobody else would do. And that was our mantra. We ended up using a phrase, we provide financial security, we'll let our competitors sell you some insurance. And it just took off. At the end of the day, we had probably 3,000 agencies using us. Mm-hmm. And we just exploded, because that was our mantra. It was drilled into the heads of everybody I hired. We're not going to sit back and act like a conduit, like our competitors.
Oh, that reminds me of that saying that nobody wants to buy a hammer. What they want is a nail in the wall. And that's pretty much like, nobody wants to buy insurance. What they are looking for is security. So,
well, that is the idea. And even today, people don't read their policies. Now, even if they did, would they really understand it? Probably not. But there are things that they could pick up on, though. Maybe the address is wrong. Maybe some of the limits are off, or made a mistake there, or some other obvious things that they could pick up on. And then, pick up the phone. Don't send an email. Pick up the gosh darn phone and talk to somebody. Say, I need help understanding this. And these policies today versus the way they were in the 1970s and even into the 80s are intentionally being written to be confusing. They're intentionally being written to be tricky. And even now, that's where the coverage terracing came from. I remember once an underwriter called me up and said, we're going to let you have something that's a secret. We haven't released it yet, but we want to show you we want to have you look over our brand new insurance policy for insurance brokers. I said, fine, send it over. So usually within 15 or 20 minutes, they get back from me something that was highlighted either in green, yellow, or red. This is good for green. This is an FYI kind of thing, in yellow, but it's important, so be aware. And then in red, like, are you kidding me? And that's where that's how it came about.
Mm-hmm. We did was it mostly, are you kidding me? Like your output?
Well, I'll give you a good one on that. This is where the coverage terracing kind of came from. The most common definition, well, first of all, in a claims-made policy, the most prevalent form today, as it evolved over time, is what's called a claims-made and reported policy, meaning that not only must the claim, the demand, written lawsuit, whatever, not only must the claim be first made against the insured during the policy term, he's got to report it to the insurance company during the policy term. And that is strictly enforced for a lot of valid reasons. But now, here's a definition of the word. The most common definition of the word claim is a lawsuit, a written demand letter, or the commencement of an administrative or governmental proceeding. Okay. You have a problem with that? Sound okay?
Not really. Yeah.
Okay, listen how subtle it is. It's a claims made and reported form, which means you have to not only must the claim be first made against you during the policy term, you've got to report it to the insurance company as designated during the policy term. And it's in the policy how to report a claim. So you better follow that exactly. Mm-hmm. The problem with that definition is that none of them require receipt or knowledge by the insured. A lawsuit that's filed triggers your policy, but it hasn't been served on you yet. A letter is mailed to you that you may or may not have received or got lost, in the mailroom or something, or got put into your spam folder. Mm-hmm. And of course, a governmental proceeding. How about a grand jury that issues an indictment, but the indictment is sealed, and so you don't know about it? So the point being, how do you report something you don't know about during the policy term? And you'd be surprised how often that takes place. So that's what's wrong with that definition. It should have a catch-all sentence. A claim will be deemed first made when any of the above is first made during the policy term. Or maybe it'll say a lawsuit served on the insured, a written demand letter received by an insured, or the commencement of an administrative or governmental proceeding that the insured has been informed of. That I have no problem with. But when it's a claims made and reported policy, you got a problem. And you haven't even gotten out of the first definition. But even better, another tricky one. Most of the policies have in boldface on page 1 of the policy form. It may even have it in boldface again on the declaration page. This policy covers claims which are first made against the insured and reported to the company during the policy term or during any automatic extended reporting provision or period, or extended reporting period, either that or provision. Stop right there. So now you got to go into because it's extended reporting provisions in boldface, and anything that's in boldface is either in the definition section or defined or in some other section of the policy. Now you got to go find it, right? So we're on page 1, or maybe even the declaration page, which is page 0, so to speak. Now you got to go on page 14 and find the automatic extended reporting provision. And here's how that starts out. If the company or the insured should cancel or non-renew, then the insured shall have an extra 30 or 60 days to report a claim, first made before the end of the policy and reported to us during the extended reporting provision. Okay? Have any problem with that language?
I mean, nothing I can think of as of now, but tell me.
Okay. It starts out by saying, if the company or the insured should cancel or non-renew the policy, they got 30 or 60 days to report a claim that literally made it the last minute, kind of thing. Served in the parking lot on a Friday night and your policy renews Sunday. What do you do, right? So the problem with that is, what if you renew? What if you renew? There's no automatic extended reporting because it starts out saying, if the company or the insured should cancel or non-renew. Well, now you're renewing. So what do you do when you served at 5 o'clock in the parking lot? You got to report that before the new policy incepts. There's your trap. Wow is right.
So are you saying that I am benefiting by not renewing and I'm being punished for renewing the policy?
That's exactly the question I've posed to underwriters. Why are you punishing a loyal policyholder who's renewing with you, and you're giving some deadbeat who's moving away from you for some reason, or maybe he was non-renewed because he has horrible claim experience.
Because when you asked me that, do you have a problem with that, and I said no, I don't, because I just assumed that if it's extended when I'm not renewing, then I'm sure it's covered when I'm renewing.
But
So
here's another one to make it better. There is a section called your duty in the event of claim or suit. And what it says is that, you must report all claims as soon as practicable to the insurance company, but in no event later than 30 or 60 days after the policy expires. So doesn't that duties in the event of claim or suit kind of deal with the problem of the extended reporting provision only applying if the policy canceled or non-renewed? I posed that question to an attorney on a matter, and you know what his answer was? That's not in the insuring agreement, and therefore it's irrelevant. The insuring agreement didn't say all claims must, we cover you for claims first made during the policy term or during any automatic extended provision or in accordance with the claim reporting requirements. If it was in the insuring agreement, then you're okay, but it wasn't. And he actually said that. I don't know why that clause is there. And I'm thinking, oh my God. And my whole purpose as a broker, I read every single insurance policy we sold, every one of them. And I'd highlight them and redline and whatever. Now, you only had to do that once because unless the insurance company updates the form, it's always going to be the same year after year. They may change some endorsements, whatever, but that was easy to look out for. And so, but that's what I trained my staff to do. We read everything. We're going to get copies of all the forms and endorsements on every quote, and we're going to send them to our retailer on every quote. It was grounds for termination if they didn't, or said, I haven't got them in yet, but it will be forthcoming very shortly. You better say that, because otherwise I may fire you. I mean, I was serious. And it was amazing, and we go back to insurance companies and try and cure these things. And if we could, great. If we couldn't, we put a special disclosure in our quotes and warning, here's a problem, couldn't fix it. The insured needs to know about it before he buys the policy. And then, that's documentation. That's how you prevent E&O claims. Just disclose and document that you did. I mean, that was something that's been going on since the 1970s, for crying out loud. But that's how we approached it. That's how complicated these policies have gotten. So back to how we started. We haven't left page 1 of the policy. The bold phase, claims must be, first made and reported during, and now we have to go track down the extended reporting provision. We're still on page 1 of the policy. We've already gotten 2 gotchas: the definition of claim and the reporting requirement, and it's gotten much worse. So so when you give service like that to your retail brokers, they're going to come back again and again and again, because they're not going to get that kind of service, or they weren't getting that kind of service from our competitors. And even today they don't. And part of that has to do with, and I don't know if we're planning on getting into this later or not, but the standard of care of an insurance producer in 37 states is you have no duty to advise your client. They have the obligation to read their policy and understand or ask questions. But unless you hold yourself out as an expert, unless you agree to do a risk management review for a fee in addition to the commission you're getting, or you misrepresent coverage, you're not, the standard of care is really what's been now called the order taker standard of care. It's kind of like they have no more obligation to advise you than your waitress at a restaurant. Wow, yeah, that's right. Only 2 states hold insurance producers to the highest standard of care. New Jersey did that by statute, and state of Florida holds by case law. Think about that. They're more liberal than people in California.
Yeah.
And then other states have these modifications. You kind of look at all the totality of the relationship, and you look at everything else. Have they been your broker for 10 years? That sort of thing. And so it varies from state to state, but the vast majority follow the order taker standard of care. And those same, I haven't done the state by state comparison, but I need to do that. But of the 37, there are now 35 states, California just joined them, where before you can even apply for a license, you had to take training classes on insurance, a minimum of 20 hours, because you could do it online. It used to be 40 in class, now it's 20 hours online. And California dropped that requirement effective 1st of January this year. So now all you got to do is buy a book, how to pass the exam, study that, take the exam, and you're ready to rock and roll.
Wow.
So you got all these nitwits running around out there selling stuff they haven't got a clue what it's about, and then they made and you know it's going to be bad. That's going to be bad for the malpractice industry because you know they're going to make a lot of misrepresentations.
Yeah.
Oh yeah, you're fine, you're covered. You know, blah blah blah.
And does this exam happen completely online or is it in
Well,
person?
it used to be done in person. Now it is done online and it's heavily monitored. They actually do it by watching your eyesight. They can tell if you're dropping down to look at something. It's really interesting. And you're going to have all these nitwits running around. That's what's going to happen. And it's just going to be worse for the litigation system. But California, a long time ago, found that even as is, before they did this, they found out that people couldn't pass the exam. So they dropped the pass rate from 70% to 60. It's been like that for more than 20 years. It's sad because when you think about how important it is,
it is, yeah.
The idea of insurance is to place people back in the position they were in before the loss. And that includes liability cases where they're being sued. Yeah. And the whole idea of insurance is to provide you with the capital to put yourself back in the position you were in before anything happened. And it makes perfect sense. But to now put nitwits out there, especially when policies are getting more complicated and intentionally so. You've already had a couple examples how subtle it can be. And lawyers are writing articles on how to hire us will help you even be more subtle. And the courts are enforcing it. I mean, I can't believe some of the maxims, so they call it, maxims of the law that drive the industry that have disappeared. Don't exist anymore. Because the contract is clear and unambiguous. So why do we have to worry about contracts of adhesion, unfair bargaining position, basically? Or the concept that insuring agreements are to be broadly interpreted and exclusions narrowly construed. Well, absolute exclusions kill that. I've been on a warpath about those since 2009, 2010, and they're getting worse. And other crazy stuff going on. I love it. Excess insurance policies, following form, right? Heard of following form excess? And now they says has a phrase, following form except where our policy differs. What does that mean? Where's the difference? And especially if you're dealing with a tower of coverage for a major company that goes into the stratosphere, like 100, 200, 300 million in coverage, you're talking 20 or 30 policies. Or maybe not that many, but 10 or 15. And now you got to find which policies below you as an excess carrier are different. Where's the difference in language? Like, oh my God. It's all intentional. It's all intentional.
So as a business owner, and I'm asking this from the perspective of a small and medium business owner, if I'm getting, or a professional, if I'm trying to get an insurance, and this is the standard insurance language, the policy language, how much can I even negotiate, even if I review the whole agreement and I understand and I can spot these nuances with the help of a professional? You
have to demand it from your insurance broker.
Okay.
You can't hire a lawyer to do it because most businesses today, even in middle market, they have to buy as many as 10 or 12 different insurance policies because of all the hazards that exist today with environmental and employment practice and D&O and E&O and what have you. And they're all different policy forms. There's no standardization. And that's part of the problem. You know, the ISO writes policy forms and what have you, but not everybody uses them, or sometimes you see down below, some of this is ISO, copyright ISO, and other is ours. Really, which is which? And, you know, you got to work with somebody who's willing to sit down with you. And I don't think most businesses can afford to hire coverage counsel and look at every darn policy they're looking at, number one. And number two, then you may have a multi-state problem. We do business in 47 states, or we do business in all 50. And then, you know, how is this policy going to be interpreted in Washington versus Oklahoma? And they are different. Same policy form, they can be different interpretations. A good example of that is an insurance company's cyber liability policy that in one state, there's no coverage for social media fraud, i.e., you know, wiring money to their own, you know, to somebody because you thought it was the president. I don't know why they call it social media, but anyways, and then another state said, no, same policy, but yeah, we're going to enforce that language. No, we believe that it is covered. And you're going to get a lawyer to do all that? You know what that would cost? Yeah, it's good for lawyers. But and I'll give you a good example of how that evolved. You ever heard of a big
Yeah,
pharmacy?
yeah, yeah. Yeah.
Huge, right? You can
Mhm.
imagine the towers of insurance that they buy
Yeah.
into the stratosphere, probably
Mhm.
hundreds of millions.
Yeah.
So, and when they want to enter, number one, they're probably self-insured for the first 5 or 10 million anyways, and then they
Mhm.
buy layers of excess of 10 or 20 or 30 million at a crack. So once they want to enter into a settlement on something, they got to go to all their insurance companies that would, who's going to have to pay the money and get their permission first. They can't start negotiating or commit. They can't commit to it until the insurance companies who are going to be paying the money till they say, yeah, we agree with this. Okay. So they enter into a $207 million settlement.
Okay.
Obviously, and they did get permission from all the insurance companies. The sixth layer of excess was at the $160 million layer. So there's already 160 million on the table. That insurance company had 160.001 up, to the next layer.
Yeah.
Had a sentence in the policy. It was not a endorsement within the policy form, and the sentence had two parts. First, all underlying insurers had to have exhausted their limits, which I would expect. I don't have a problem with that. Don't come to us until there's 160 million on the table. And it was the second part of the sentence that just blew me away. All underlying insurers had to have admitted liability. Not the policyholder, mind you, insurance companies. Have you ever heard anybody admitting liability in any settlement? Anyone? Certainly not the policyholder. Oh, we didn't do anything wrong. We just want to get this behind us. Insurance companies had to admit liability. And the argument back was, well, they paid their limits, so obviously they are. And the court said, no, they have to actually admit it because that's what the policy requires. Strict adherence. And so Pharmacia had to cover $47 million out of pocket because not only was that insurance company gone, but everybody above them as well. Right. And I was flabbergasted. And then you read the actual appellate decision, because this was in New Jersey, the Third Circuit. They cited a previous case involving the same exact language for the same exact insurance company that was upheld in 2012. Well, this was 2024. So I didn't hear anything about that. I didn't read it in any of my, appellate feeds from law firms and whatever. I get those every day. I never heard of this case, that earlier case. I went, wow, you mean there's another one? And I just was flabbergasted. And then you had a law firm, there are a lot of law firms jumped on it. They write reviews of the file case. They put it out on the internet and, whatever. I must have gotten 5 of them. And there was this one law firm that ended their review. It was perfect. And it described exactly what happened. It was the last sentence that got my attention. It would behoove insurance companies to hire knowledgeable coverage counsel to help them draft policy language so as to be able to reduce their payouts and their expenses. Why buy insurance? Why buy it?
That's what I've been thinking the whole time. Yeah.
Well, and another attorney that I know very well wrote a guest editorial for the D&O Diary. I'm sure you've heard of the D&O Diary, Kevin LaCroix. And it was in 2019, and D&O insurance was getting expensive, especially for publicly traded companies. And so he wrote it. This one attorney that I happen to personally know wrote an article about how you can add to reduce the exposure and keep pricing down. He suggested up to 19 additional exclusions in the policies. And of course, make them all absolute exclusions.
Okay.
Lord, so why buy the policy? It doesn't cover it. So you're going to have one kind of claim covered? What's the point of that? And absolute exclusions are really turning into a nightmare because they're being so broadly interpreted now. Because unfortunately, they're not limited to the actions of the policyholder. I did a big article for ERMI on this in 2021 and looked at 30 cases, absolute exclusion cases. And a couple things stood out. Number one, it's intentional. Number two, lawyers and accountants had the fewest absolute exclusions in their policies. Insurance agents Directors and officers and miscellaneous professionals had the most.
Okay.
And here's the danger of that. When I read a policy and I go to the exclusion, and I get to the exclusion section, they usually fall into three categories. An absolute exclusion that says refers to the insured. We don't cover any claim arising directly or indirectly from committed by an insured. Now, I don't have a problem with that because usually those exclusions are there because you have another policy you can buy to cover that. Don't look to your E&O policy to cover you for an employment practice claim. Don't look to your E&O policy to cover you for product liability claim. Buy that kind of policy. And that makes sense to me. It's like every liability policy that exists excludes any claim that would be covered by workers' comp, except a workers' comp policy. And that's a good example of it. So, or it may say we don't cover any claim arising directly or indirectly from blah, blah, blah. Doesn't refer to the insured. But then it says this will not apply where the insured is providing a professional service to a customer. Oh, okay, I have no problem with that. Good. It's when it doesn't do either. We don't cover any claim arising directly or indirectly from any environmental or pollution hazards. Period. Doesn't refer to the insured. There's no carback. So when you're an insurance broker and you're selling environmental liability policies and your policyholder gets sued on an environmental matter and for one reason or another claim gets denied and he wants to blame you, the insurance broker, oh, you didn't get what we were supposed to. Is the E&O carrier for the insurance broker going to cover it?
No.
And I've seen as many as 14 exclusions in an insurance broker policy that do the same thing. So they're routinely selling 14 different types of coverages and don't realize they have no coverage if something goes wrong. And miscellaneous professionals, fill in the blank, what I do for a consultant of some kind. They have the worst. They have more than 14. And one of them is failure to procure insurance.
Mm-hmm.
Well, what do you do if you're an expert witness handling professional liability cases against insurance agents and brokers? It took me 4 years. 4. I'm a member of an association of experts, and it took me 4 years to get a Lloyd's-based carrier to agree to drop the absolute language and limit it to the action of the insured only, so that we would actually be covered. And it took me 4 years to do it. And other people would take that policy form, members of the association would take the policy form to their other broker, said, look at this. Can you get me something like that? Maybe cheaper or something? They come back and say, no, you've got something nobody has, which is true. It's true. It took me 4 years to do it. And, it's ridiculous. But this is what's going on. And it's being done intentionally. Insurance companies have forgotten what they're doing. I mean, a lot of insurance companies now are run by MBAs and accountant types of mentality, and they don't even know what insurance is. They haven't got a clue. All they know is they got this huge cash flow. How do we keep it?
Yeah.
And then they get mad when there's a nuclear verdict. Well, that's their fault because they didn't evaluate the claim properly, because they didn't investigate it timely, and their attorney, defense lawyer saying, well, yeah, we can beat this. We can do this. It's not worth more than $100,000, and then they get hit for $20 million. And because they're not doing what they used to do, which is develop the case. Like I said, in my claim days, we could have the claim as factually developed as possible in 90 days or less. You can't do that. You can't even get a scheduling order in that pace time. And you're never going to get all the facts that you can do that way anyways. And properly evaluate, properly reserve, and get the thing resolved. And we proved with the claim audits that we did, that when you do that, you're going to save a lot of money, a lot. We did one of the first claim audits where this came up. Well, we had to review 5,000 files. I mean, oh my God, it was horrible. And we made the recommendation that, look, you're going to have to double the claim staff to get this under control, because everything's a fire. Everything. That's all the time these claim people have is to handle fires, which means the ones that aren't a fire yet are going to not get any attention until they become a fire. And so what do you think you're wasting on attorney's fees and settlements because of that? And they asked me what do I think it would save them? And I said, I think it'll save you 5 to 1. And I was wrong. It ended up being 10 to 1. They spent $1 million to double the staff, and it ended up saving $10 million a year or more. They dropped the claim volume, open claim files dropped. The amount of money being spent in defense fees dropped dramatically because now the files are being investigated. Now the files are being closed faster. They're fighting when they have to. They're settling more cases. They had 100% closing ratio for every claim that came in. Another one was closing, and it was amazingly successful. But that was only one example of it. And unfortunately, my audit reports for that client over a period of time were the only ones that survived. We did a lot of other claim audits as well for others, and for whatever reason they didn't survive. And so I can't go around saying, here's one result and act like it's going to be all the time. But another person I know has done a deep dive and has written a draft white paper on this very topic. And I think it's going to be released very soon. And if so, boy, it's going to settle. It's going to be explosive because basically it verifies empirically exactly what I've been saying for years. If you can develop a claim in 90 days or less, you're going to settle it faster. And that's your profit right there. That's how insurance companies make a profit. You don't make a profit by stall, and then get hit with a nuclear verdict and go whining to, oh, this is so wrong and unfair.
So why do you think
it never would happen?
Yeah. So why do you think they deploy the practice of stall?
Short-term thinking, short-term profit making. One of the biggest fears right now is capital surplus. A lot of insurance companies are actually borrowing short-term money from hedge funds and private equity companies and using that to beef up their underwriting. But they're not supposed to do that. Capital surplus is supposed to be unencumbered. And everybody's thinking short-term profit now. And especially smaller insurance companies where, oh, good, we can sell out to the big boys, make a lot of money, and let them get stuck with the long-term, tail, which is happening.
And there's no oversight on how the insurance companies are going about their business. Like, is there a regulatory authority that looks into all of this, or it's
the Department of Insurance? The departments of insurance don't have the funds to do the kind of claim auditing they need to do. So I think the frequency of outside claim auditing has dropped dramatically. I don't know if reinsurers are doing that, but they're playing hardball on other issues. I mean, they have a treaty policy with their client, and if they catch them doing something they shouldn't have done, they're not paying. And then a lot of reinsurers are not as heavily regulated as issuing companies, fronting companies. And so there's a lot of shenanigans going on with reinsurers as well. Excuse me. If they suddenly disappear, you're stuck. But that's rare. It's rare. But they're not as heavily regulated, perhaps they should be. But that is what I'm seeing. And so as a result, insurance today is nothing like what I was growing up with. And it's certainly, you're not seeing insurance companies doing the right thing. I mean, I've been involved in some cases that are just freaking stupid. I'm not going to mention names, but there's one company I know very well. And I had a very long-standing relationship with them, both in claims and then as a broker. And they are really smart guys. They got involved. They jumped on a very bad loss immediately. And then once they jumped in, they realized we don't have coverage the prior carrier does. And the prior carrier said, well, you're on it. Have fun. Literally. I'm not joking. It was like, what? So they did the right thing. They settled the underlying loss, stop the bleeding, get the plaintiff out of the case. And then we'll seek equitable subrogation, whatever, equitable contribution from the carrier that really had the coverage. And the other carrier is acting like, some multi-billion-dollar company like them isn't going to worry about a couple of $1 million. So they never offered more than $25,000. Were they out of their minds? I mean, I know that company really well. And to sit there and say, oh yeah, multi-billion-dollar company ain't going to worry about $1 million, yeah, they are. This company's going to do that. And so they went all the way through trial. At the end of the day, they got $4.5 million. It's because of stupidity. But that was the right thing to do. The key was getting rid of the plaintiff. There was no way they were going to win that case on defend it. It's clear liability. Get them out of the case. Now the damages are set in stone. Now let's get our money back.
Mm-hmm.
I got another case that is going to trial. Same thing. Why is the plaintiff, the policyholder, in this case? But we have a fight between two insurance brokers. Oh, you're responsible for it. Oh, you are. Fine. Take them out.
Yeah.
And they wouldn't do it. It's got to be crazy. It's all who's, you should have taken them out and then you could have arbitrated it. You didn't even have to go to court. You could have done an arbitration on it and to see who should be paying what, but they wouldn't do it. So as a result, they've wasted so much money on this case. It's unbelievable. Mm-hmm. It's well into the 7 figures, I'm sure. And it was unnecessary. And then, of course, if there's a nuclear verdict, which there could be on this one, it's like, oh my God, this is so unfair. All preventable. I would like to see somebody do a hindsight audit on these nuclear verdicts. Where did it go wrong? Where could they have settled it for a reasonable amount of money and avoid this whole thing? I would love to see that happen. And like I said, I don't know if there's the kind of auditing going on. I don't know if they're bringing in third-party auditors, if the departments of insurance are having money to do it, or even reinsurers. I really don't know. And so that's a question mark on my part. But
because the insurance companies are not going to do it, and even if they do it internally, they're not going to publish it. So that's
it depends. If they're publicly traded, I'm not sure what the rules are on that. But and of course you have more and more market consolidation going on.
Mm-hmm.
I mean, now you got Zurich is making a play on Beasley. Originally, I thought Chubb was the one that started that thing, and I'm thinking, oh my God, no, Beasley's a really good company, but Zurich ain't much better. I mean, I have my issues with Zurich too, and they're all thinking short term, all of them.
Yeah,
and I've done this openly now on LinkedIn. Buy from Lloyd's. Now, are all Lloyd's syndicates good? No, but a lot of them are, and a lot of them still use 1990 policy forms that actually cover stuff. And they still, a lot of the syndicates still use boots on the ground investigators and adjusters to get on your pony and get over to where get statements and photographs. And they're really good at developing the loss. So they're doing it right. So they're growing like crazy and profitable like crazy.
Mm-hmm.
And the way insurance companies in the United States are earning profits is deny and delay, which ultimately will catch up with them.
So let's talk a little bit about the attorneys who practice insurance. And you've taught Insurance 101 for young attorneys numerous times. And we also see a lot of plaintiffs' attorney chiding insurance companies, blaming them for, again, like the delay tactics. And on the other hand, we also see claims adjusters and defense attorneys blaming the plaintiffs' attorneys for driving the cost of insurance up by bringing in frivolous litigation and increasing the cost of defending these claims for them. So, do you feel that new attorneys whom you've taught Insurance 101, what kind of handle they do have on insurance-related matters? And what are some of the biggest knowledge gaps that you see in these lawyers?
Well, number one, what's the focus? There are very few law firms that are saying, we negotiate settlements.
Okay.
We're focused on getting the case closed. The best file is a closed file. And there's very few law firms that have that as part of their mantra. There's one law firm that has, the guy's even one of the partners, and they're a fast-growing firm. Their focus is settling cases.
Mm-hmm.
And the problem is you don't always have cooperation of the plaintiff. Sometimes they're asking for the moon when they're not even entitled to a stone. But they think the more we push, the maybe we push, and we might get lucky at in front of a jury, and there's some truth to that. In all the cases I've handled, and I don't know, I should have corrected that for you. I've probably testified in 30 or 40 trials since 2009. And I've handled 160 or more cases, or maybe more than that in that time period, but much higher. And only once did I have a verdict that really shocked me. And it really boiled down to, they really liked the plaintiff expert. She was a woman, and she came off all warm and fuzzy and cuddly. And I was there to talk about the standard of care. They thought I was being arrogant. And I don't know what I did to give them that impression. But nonetheless, so they gave the plaintiff what they wanted, and the verdict was clearly wrong. I mean, the plaintiff in this case was more negligent than the broker.
Wow.
I mean, they were complaining that the broker, misrepresented 2 items. Well, that's fine. How about the 7 that the policyholder never discussed? I mean, 7, at least 7, maybe more than that. And they overlooked that. But it really boiled down to the jury. You never know what that jury is going to do, no matter how strong your case, now how good a lawyer you are, how good an expert. They either buy into what you're doing or they don't. And this one jury, for the first time in all the trials I've seen, just didn't buy into it and didn't see the problem. So they wanted to give the plaintiff what he needed. Now, there were some other mistakes made, and the case is being appealed. So you never know what a jury's going to do. So that's problem number 1. Problem number 2, plaintiff attorneys always like to squeeze as much as they can. You're seeing a lot of that, and it's getting worse, especially on these fires. They're hiring public adjusters or whatever and jacking up the costs as much as they possibly can. And then you got problems with health medical claims. What's the damage? What you actually had to pay, or what the billing was? The billing is BS. I mean, I've seen people get sick and have bills that totaled $357,000. But because you had insurance company only paid $50,000, and that was paid in full. The patient wasn't responsible for the balance. So from a legal standpoint, what's the damages here? $300,000 he was billed, and the $60,000 that was paid in full.
Yeah.
See, so you have those problems, and it's fueled by greed as opposed to making good sense out of what's right, doing the right thing, which is something I've always believed in. Always do the right thing, and so sometimes you have no control over that. But I think the number of cases going to trial could be significantly reduced by being smart and doing the right thing. I got a case going to trial right now that, I already told the lawyer, the damages here are under $50,000. Said if you can get 3 times that amount, take it and run. But the insurance company won't do it. The defendant won't do it. They want to go to trial. I'm thinking, gee, this could hit for a nuclear verdict, because, it is pretty egregious conduct. We've got some, and it's very something that the jury can relate to. They had a flood in their house. And from day one, the claim guy said, I'm not going to replace anything. We're going to repair it. Well, that's not the code. If you can't get 2 colors to match, you got to replace, not repair. That sort of thing. I found something like 74 violations of the code and testified to that in deposition. They still, I don't get it. I've seen such crazy stuff. One big insurance company, I'm pretty convinced, had a budget, cash budget by region. Here's so many million, that's got to last you 90 days to settle claims and pay claim expenses. Lawyers are the worst at getting their claims, their legal bills paid. Sometimes they have to wait 6 months or more to get paid. That's ridiculous. You're strangling your own vendors, but it's all that cash management. And they want to try and keep as much of it in-house. And it drives me crazy, because on an accrual basis, from an accounting standpoint, when you set a reserve of $100,000, you get to deduct that right away. But the money's still sitting there, but you're able to deduct it. Now, granted, if you settle for 50, then the 50,000 that comes back to you, that's treated as ordinary income. But still, what's the point of that? Settle the case. Early settlements will always be lower than waiting until the eve of trial or taking a trial and getting a defense verdict. You will never, ever recapture that. And that's been proven time after time. But the whole industry's got, their head up their rear, and they're getting, and the courts are supporting it. That's what really blows me away. I did an article for the Professional Liability Defense Federation. I did put it up on my website. It's called Litigation is Good. But it goes over how many of the maxims of insurance that I grew up with have disappeared because of this fanatical belief in the sanctity of the written contract, that if it's clear and unambiguous, we're going to enforce it, even if it isn't so clear. It's clear to us, we're a judge, not clear to a consumer, but clear and unambiguous to who? But they're enforcing them. And that has changed things dramatically. And I don't know how that's going to change unless it's going to be legislative.
Let's talk a little bit about your book, the one that you wrote in 2024. Yeah,
claims-made insurance. The policy that changed the industry.
Yeah, because the one thing that really popped out for me was you documented over 224 appellate decisions involving policyholder errors with claims-made policies.
Yes.
So can you shine a little light on that?
Oh my God, I did an article that was published by the International Risk Management Institute in 2023 that looked at 224 claim denials. But there you're dealing with strictly the claims made trigger. You're dealing with the definition of the word claim, and there's 20 or 30 of those. And then where the subtleties might be, like we at the beginning of this I discussed. You like that one definition. Well, yeah, but it doesn't require receipt by the insured. That's pretty subtle.
Yeah. And
then you have variations where there'll be 4 definitions of the word claim. 2 of them require knowledge or receipt by the insured, and the other 2 don't. That's sort of, you get all those variations. And then you get all sorts of good definitions and bad definitions. But, the claim made trigger is bad enough. But there's all sorts of other tricks and all sorts of other things you need to be aware of, like extended reporting provisions and options there. Like, for instance, when you're dealing with a claims-made policy, one of the things that can affect you is if you get acquired. Your policy, on the day you close that deal, your claims-made policy immediately goes into what's called runoff mode. They're not going to cover you for any claim made during the policy term if the mistake you made was after the acquisition. They'll only cover you for mistakes made before the acquisition, so long as the claim is first made before the policy expires, or you can buy an extended reporting provision. And there again, it gets tricky. Does the policy say you only get 1 year for 150% of the expiring premium? Or does it give you multi-year options, 1, 3, 5, and 6-year options with pricing? Or does it say, we'll charge you X amount of premium for whatever number of years we're willing to do based on our underwriting guidelines at the time you need it? Well, yeah, really. What if maybe it's not an acquisition. Maybe you're being non-renewed by the insurance company because you've had 4 claims that year and they don't want to touch you. And you think they're going to be generous with the extended reporting quote based on their current rules and regulations at the time you ask? Right? There's one right there. You want a policy that gives you up to 6 years, and right away what the pricing is, because now they have no choice. I saw one insurance company, and granted, the risk was in terrible shape financially, and with a director and officer policy, and they wanted to quote for extended reporting 800% of the premium. And I can't say I blame them for that. But if they had preset the pricing and said, oh, yeah, we'll charge you 300%, they're stuck.
Mm-hmm.
But most policies are preset. So that's another thing you got to keep an eye out for. But the consumer wouldn't know that. Broker would. Because he's seen them, assuming, well, maybe he wouldn't, because a lot of brokers don't sell the policies they sell anymore. They don't read them. And here's your policy. But you also have to remember the mindset of most buyers today. It's almost like propaganda. It's almost like brainwashing. Yeah. Every day you see ads, you hear ads on the radio or streaming, whatever. And, oh, I just saved $400 on my auto insurance. Oh, I saved $300 on my homeowner insurance. Yeah. Oh, and so number one, it implies that every policy is the same, and they're not. They're not worded the same. Sublimits and special other add-on coverages may differ from carrier to carrier. I mean, one insurer may only insure you for sewer a homeowner policy may only be insured for sewer backup up to 5,000. Somebody else might do 10. If it's a commercial, you might even be able to buy it up to 250,000. Like a restaurant might need that. But nobody looks at those little sublimits. And there's where the difference is. That's why you're saving $300. But everybody thinks that all policies are the same, and it's just a difference in price, and that's wrong. Number two, never buy price. Never. Because what are you giving up? And you don't find out until you have a claim. And that's not when you want a surprise. And that's happening more and more. And ignore for the fact that after these horrible, horrible fires we've had here in Los Angeles last year, with whole neighborhoods being decimated and thousands of homeowners with claims, I would bet you the vast majority of them were underinsured. And not because the supply chain problems, whatever, or I've heard numbers like $1,000 a square foot to rebuild. I think that's just being greedy on the part of some of the contractors. I don't believe that, but $500, $600 a square foot because of supply chain problems and demand at the same time, that's possible. That's possible. But people don't think like that. I do. I raised my limits on my home. I probably have more insurance than the house is worth on the marketplace, which now you're dealing with the land value and the location value. But to rebuild it right now, probably more than the house is worth. Doesn't make sense, but I am attuned to that. So I did increase my limits and stuff. But most people don't think like that. Even commercial buyers think of insurance, oh God, an evil necessity. Let's just get it over with. And they don't think about the fact that we could have a serious claim, whether it's from a fire or a third-party lawsuit. And, if you better be forewarned, never buy on price, buy on coverage. Yeah. Now, a lot of brokers, and I'm one of them, I would never recommend limits ever.
Okay.
I mean, that's just suicide, especially liability limits. Because, I can always, 100 million. Oh, I can think of a claim that costs you 200 million, so I never would recommend price. What I would, however, do, and we did it routinely, is we get automatically, we get a thumbnail. Not a formal quote, but here's your quote for $2 million. And just out of curiosity, and just so you know, you could buy 5 or even 10 million in liability. And here's the approximate pricing. Let us know if you're interested. Now we've covered the bases. They can't come back and say, oh, we were underinsured. You should have told us. Well, we gave you indications for 5 and 10, and you said no. Game over. You're not giving advice. You're just saying, here's some options. I never said you need 5 million, you need 10 million. Whether I thought it or not, to recommend limits is suicide. And I actually handled a case where a broker did that. He said, oh yeah, 5 million is enough. He did it in writing. And then after this horrible loss, he did it again. Oh yeah, 5 million is still enough. Are you crazy? You got a $10 to $15 million claim against you right now. And you're telling him 5 million is enough? How dumb is that? So,
but then, where does one then draw the line? I mean, again, it'll like a lot would depend on the kind of business it is. But would you always recommend a no limits policy is what like business owners should be going for?
Low limit policy? Never.
No limit.
Sorry. Oh, no limit? I don't even, there is no such thing. There's no open-ended thing like that. You have to get a limit. And then, of course, if they want too much, you're going to have to get excess insurers. But it all depends on the situation, too. There was this one client I had, and we were a wholesaler on it, but we worked very well with their retail broker. They always had us go to the meetings for renewal. And this was a small family company when it started. And now they were still running it like a small family company, but they were construction managers on large projects. I mean, bridges and highways and they're still running it like a small family company. Oh, you guys nuts. And they finally got talked into, oh, well, I guess we have to buy professional liability coverage. You think? They only had $1 million limit. So they found themselves as a, shotgun defendant in a case because they sue everybody, right? So they were involved and they only had $1 million limit. The case had an exposure of over 35 million. And these guys were in a target. It was really a construction error or design error, not if their failure of these guys as a construction managers. And so they weren't a target. But when the plaintiff attorney saw they only had $1 million limit, out went the policy limit demand. And their insurance company said, here's your check. We're out of here. Because if they'd said no, then the lid's off the policy. So the insurance companies have to settle a case within their limits if they can.
Yeah.
And if they don't, they're taking the lid off. So when we saw the account, we saw the $1 million loss. We understand the explanation. I knew right away what happened. And they had 10 million in insurance. And I thought, well, that's better, but they really need more than that. But the way it was structured blew my mind. I was like, what is wrong with these people? They had a $2 million primary limit. Then they had another $3 million to go to 5 from another insurance company. And then they had a $5 million excess of that to get to 10. And I'm thinking that's insane because they've just set themselves up for the same problem. Because as it turns out, an excess insurer, no, strike that. The primary insurer has the same obligation to an excess insurer to settle within policy limits as they do to a policyholder.
Oh, yeah.
So they could get a $2 million loss now on their loss run because send out a demand for $2 million, and now you're going to have help from the excess insurers to settle the case. And I explained that to them. And I said, I've got 2 insurance companies fighting over this account. Not only can they give you all 10, they both can give you 20. And that way they have enough on the table at stake to say no to a policy limit demand, especially if there's no liability or very little. And they listened to me. They paid a little extra money to get 10 with one carrot. So they didn't have to worry about a policy limit demand. And they're not as much. And I still quoted 15 and 20 options as well. Same insurer. They turned them down. I never recommended they take it. I just offered. So my rear is covered. So, and it worked out very well. They never had a bad loss. But that was a big account. And it's all in, again, having some legal knowledge and caring about the need of my customer. If you do, and of course, everything has to be documented.
Yeah.
The likelihood of a professional liability claim is very low. You can't stop somebody from suing you. But we never settled. We never gave consent. And we were so well documented that the lawsuit was never even served on us. We got rid of it in the threatening stage, so to speak. Only once did we end up having to go all the way with it. And I wouldn't give consent to settle, and ultimately we were dismissed. And we had them set up for malicious prosecution, and I decided not to pursue it. It just wasn't worth the grief. I've been involved in litigation all my life. I feel like I don't want to be one of the players. It's too crazy.
Yeah.
But this has been our approach. That was my approach as a broker, with my approach as a claim person. And then as an expert witness, as long as I stay in my lane, I don't venture out of my lane. I turned down a case yesterday because that I got over the weekend. And I said, it's a little bit out of my lane, and I'm not comfortable with it. And frankly, the only reason I'm doing expert witness work now is because I need a reason to get up in the morning. And see, I'm not ready to retire.
No, I mean, I can see you're clearly not, like, all the energy and the joie de vivre that you have. I really feel that.
Je parle français. Oui, joie de vivre. Je ne sais quoi.
Yeah. So what's your typical engagement like? Like, how early do attorneys bring you in? And you also have been able to manage a very close, like almost a 50-50 split between defense and plaintiff. So is that intentional? How do you manage that?
It is not intentional.
Okay.
But number one, I only take cases I agree with. I won't take cases that make money. And there are plenty of those guys that will. I won't do it. If I don't like the case, I won't take it. And if counsel hasn't been upfront with me from the beginning, and all of a sudden in the middle of things, I find stuff that, we got a serious problem. I'm on the phone immediately to counsel and say, we got a problem here. And I have actually had to withdraw from cases because of it. I mean, I will. And it's in my letter of engagement. I need to know the downside here. And sometimes I've taken cases where I've narrowed the scope of my testimony. So I'm only dealing with one issue or one aspect of it. And so I can do that too.
Mm-hmm.
But I'm very honest about that. If I don't agree with the case, I won't take it. And they better be honest with me. And other than that, I think I come across very believable. And then of course I watch how many cases I've got open at the same time, because the last thing I want to do is get jammed. But sometimes you have no control over it. Sometimes you think, okay, my calendar is looking pretty good, and nothing coming up, and all of a sudden trial dates get changed, and all of a sudden you got 3 trials scheduled the same week. Oh my God, no! But so there are times where it can be very, very stressful. But for the most part, it's rare. And then sometimes you just shake your head. I can't believe this case is going to trial. Yeah, but plaintiff attorneys sometimes just want to take the dice roll because they're always hoping to get a sympathetic jury, and they may or may not.
Yeah.
And these days, the jury pool in California has been dramatically improved by some new laws that were passed many years ago, where no one is excused from the jury. I don't care who you are.
Okay.
Oh yeah, you could be a judge, and you get that notice, you better show up. And the same with lawyers and doctors and whatever. They may give you the right, okay, you want to postpone it, fine, but you have to show up within a 6-month period once we've selected your name. So the jury pool has gotten a lot better.
Nice.
And so you're seeing doctors and lawyers and engineers and what have you on the jury. I get my notice every 2 years or show up. And they never want me on the jury. even the criminal cases, yeah, I don't want him. But you still got to show up. So I think that has helped. But yeah, there is still nuclear verdicts going on, sympathetic plaintiffs and what have you. I mean, there was one case I was stunned that the jury reacted the way they did. I mean, on the same token, nobody likes to see grandma get hit by a car. But the fact that she was in a crosswalk where she shouldn't have been because there was construction going on, and it says, and they had barricades, don't walk here. And they ignored that. They ignored the fact that a sub rosa investigation 2 weeks before trial showed that she wasn't injured at all. She was doing just fine. And then she comes in the court with in crutches or with a cane or something. And that was just nonsense. But they liked her. So sometimes it's just jury does whatever they're going to do. And you have no control over that.
So a lot of attorneys these days talk about doing focus groups, and they feel that it's really important to have those before you decide and to value a case or like how a jury is expected to react. Do you have a take on that?
No. Focus groups, you mean, talking about expert witness work and how to avoid nuclear verdicts or something?
Yeah, I mean, a lot of plaintiff attorneys would also do focus groups with juries, so mock juries, and they'd like poll them on, okay, this is the case, and what do you think this is worth? How would you, like give the
There's a
verdict on
whole
this?
industry on that.
Yeah.
Yeah. I've never been asked to participate in one of those. Frankly, I don't know that I would. Just because, I'm winding down. Maybe in a couple of years, I may actually, end up spending my time at animal shelters and walking dogs.
Oh.
No, I have not done that. And one of the reasons being that's just another area of marketing, and I'm pretty busy doing what I'm doing now. And they want me, and now my publisher's on my back to write another book called The Gotcha That'll Get You, where I deal with policy language across the board, homeowner policies all the way through complicated commercial forms, and how bad these policies are getting. And here's what you need to watch out for. Kind of like insurance for dummies and copyright trademarks acknowledged there, but something like what they do. I mean, they're good for consumers, and this one will be even better than the one I'm doing because I'm dealing with the real world. I get these feeds every day on the internet from aggregators as well as law firms that send me their latest and greatest review, and that's how I stay up to date. And to me, it's scary how bad the insurance industry is getting, especially United States-based carriers. It's all about profit. They've forgotten what their product is. Their product is to place the insured back in the position they were in before the loss. And somehow, that has been strangled by this insane belief we need profit, we don't, whether deserved or not. And I don't believe that anybody should be entitled to a profit if they make a crappy product. And so I don't like, I'm a firm belief, if you don't provide a quality product, you don't deserve to earn profit.
Mm-hmm.
And you see that difference in mentality between us and Europe and Asia. Well, they do build quality a lot. I mean, I don't want to paint a broad brush because there are some countries I would not buy anything from, but for the most part, they do believe in quality products, whether it's in their food or their medical delivery systems or what have you. I mean, we're the only country in the world that doesn't have free medical care or heavily subsidized. We're for profit driven. And again, is it any surprise we have some of the worst medical delivery systems in the world for any modern country? We're ranked last because it's profit driven. We don't want to take care of you because it's too expensive. So it's pretty sad. But it's an industry that really needs to have start looking in the mirror. And everybody is so pressured to produce. And it really is sad to see this happening. This is not the insurance. What I'm seeing today is not the insurance industry I grew up with. And people are making some really bad and stupid decisions. And I have no problem calling them out on it when they do. I mean, I mention names, but I'll call them out.
Mm-hmm. And you've been doing this for more than 30 years as an expert witness. So, shine some light on how the role of an expert has changed, or has it changed at all? Are juries more or less receptive to expert testimony today than they were when you started?
Well, it's a state-by-state issue, number one. Even the federal rules have gotten tighter on the role of an expert can play. But I've always been a firm belief that, and I've written articles on this, so I'm not saying anything that can be later used against me. But I really think the role of an expert, number one, is to be as neutral as possible. I really don't care whether the plaintiff wins or the defense wins. I care about what's true. And it's rare when I've had a case where we're 100% clean one way or the other. There's always going to be some kind of question of fact. The question is, how important is that question of fact, number one, and what could have been done or what wasn't done. And then, of course, you got the problem is, especially when I'm on the defense side, the plaintiff still has the burden of proof to say, hey, you screwed up the coverage. And my response is prove that it was available. I mean, sometimes you have unrealistic expectations, or the plaintiff does. Oh, we should have had this covered. Well, it's not that easy, counselor. And by the way, you've got the obligation to prove it was. You've got the obligation to say this could be covered. And from what I've seen, no, it's not. And or the reverse, the defense is playing hardball. And it's like, are you guys crazy? And here's why. But like I said, I don't advocate. I just call it like it is. And I've called out other experts that they're advocating. They're advocating the plaintiff's position. I remember one expert talked about how somebody was unceremoniously fired. And my response to that was, well, should they have been ceremonially fired? That is, those kind of adjectives do not belong in an expert report. Or in another one, somebody listed out all these different errors, and he really slanted it about bad it was and evil it was and stupid it was and on and on and on. And I said, all that is inappropriate for an expert witness. And number two, they did. Everything you're complaining of, they did. Not themselves, because they didn't have the knowledge. They went to a wholesaler. And that wholesaler advertises their expertise. That wholesaler advertise how they're experts in hospital malpractice insurance. They even did a side-by-side comparison of the policy being quoted with the renewing policy and pointed out how this policy is much better, and it was. And oh, by the way, this is the same wholesaler that's been involved in this account ever since day one, 8 years ago. So what are you complaining about? And I did my own side-by-side comparison. Oh, by the way, they did miss a couple of other items. So clearly the policy they recommended was better than the one that was expiring. And I understand that I got a phone call after that report. 2 weeks later, the case settled because the plaintiff capitulated. I just blew their expert out of the water. But to me, either it's right or it's wrong. And I'm not going to try and take something wrong and try and make it right, or the other way around. It is what it is. And as long as I've got all of the facts, great. And then it's just a matter of applying it. And I do my best not to use inflammatory language. I do my best to be straightforward and appear to come across as a neutral, which I really think is the role. But sometimes the case is so obvious, sure, I'm going to be strong in my opinion, but show me some facts that would change my mind.
Yeah.
And then I will. I mean, one of my biggest problems right now is what a surplus line broker is they're allowed to sell insurance for not what's called a non-admitted insurance company, and it requires what's called a special license. So first you have to have a broker license, and then you're qualified to get a surplus line license if you want to. And almost all wholesalers have that. A lot of retailers don't, but then a lot of retailers do, but that's a case-by-case basis. It's just not required. If you don't want a surplus line license, then you go to a wholesaler that does. And so in this instance, I've had to withdraw from a number of cases because I was hired to represent the defense, and I'm representing a brokerage that was a wholesaler. And then I look up their licenses like I always do. Sometimes I even do it when I'm on the phone with the attorney for the first call, the first discussion. And I find out they're not licensed as one. That's it. Game over. I can't. How do I testify that they lived up to the standard of care as a surplus line broker when they weren't licensed as one? So I had to withdraw. I can't do this. So you do see that. And then of course this again goes to the education of the attorneys. A lot of the trial partner might know this, but the young associate that's doing the workup for him doesn't.
Yeah.
They may not even know what a non-admitted insurance company is, or what's the difference between that and an admitted one, and why. Or they don't have a clue of what the product distribution models are, between retail and wholesaler and managing general underwriter. I don't like to use the phrase MGA, MG, because a managing general agent is statutory. And most people don't know that. And so it's another grossly abused phrase. But there is a lot of states do have a license to be a managing general agent. So it's greatly abused. So is agent and broker. Those are also abused words. So I never use the phrase MGA. I always use MGU, managing general underwriter, because there's no license for that. It's just a business model. And so that, again, a lot of young attorneys, they haven't got a clue what the models are, production models are, especially first or second year. And so that was the purpose of the Insurance 101 class. In literally 70 minutes, they learn what might take them 5 to 10 years to learn the old-fashioned way, which is a little here on this case, a little more on that case. And after 5 or 10 years, oh, yeah, I finally understand the insurance industry. But at least in 70 minutes, they get a crash course. And here's all the things you need to know. And this is how it functions. And, of course, the 3 different claim department models. There's a minimum of 3. And they don't even know that. I mean, why would an insurance company hire a third-party claim administrator? Well, maybe they don't have enough staff, or they don't have the expertise to know what somebody does. That sort of thing. And then my favorite money waster, monitoring counsel. God, talk about money being thrown out the window. But you see that too. But, the young associates don't get that until they've been in the business for a while. And then then they finally do. And I can teach them that in 70 minutes.
I see the Insurance 101 for defense lawyers as a course is offered on the Academy of Insurance's website, and it's available for $129. Do you also have something for plaintiff attorneys, or this is only for defense lawyers?
What you just mentioned is the one I just described, Insurance 101 for new attorneys.
Yeah.
Plaintiff attorneys can benefit it as well, although they also have their own biases. For instance, insurance companies don't like to settle because they want return on their reserves. Well, there is some truth to that. However, on the same token, it doesn't pencil out. You got 100,000 in reserve, even at 10% return, which is rare. That's $10,000 a year. You can't hire a defense lawyer to file a demur for $10,000. So no, it doesn't pencil out. Litigation is expensive. And so no, insurance companies don't not settle because they want to make money on their reserves for as long as possible. That's wrong. It doesn't, even with what's going on today, where they're under reserved anyways. Yes, they make a lot of money on their reserve. When you look at how much they're paying on claims every day and claim expenses, no, it doesn't pencil out. And they can strangle the defense lawyers as much as possible. I mean, I've seen some attorney management guidelines from insurance companies that I'm just astounded. They're tying the hands of the defense lawyer. They can't even breathe without permission. And it's like, what are you kidding? What are you accomplishing from this? You're tying their hands. In other words, again, they're not developing the claim. You're in the dark on what this claim is all about. I can guarantee you the plaintiff isn't.
Mm-hmm.
And so they don't get that. Now, you also don't want your defense lawyers running amok either, but still, I've seen horror stories because of it.
Wow. And what advice do you have for young claims professionals who may be thinking about doing expert witness work? Like, after all these years, would you tell them to, hey, stay away from it, it's not worth it? Or would you encourage them to join? And if you'd encourage them to
If
try...
they're allowed to, that's the problem. When you're a claim guy, you may not have the time to do that. If you get into management, like a claim manager or senior VP,
Yeah.
that's another story. You can do that when you retire, because certainly you know a lot of good defense lawyers for sure, and you may even know a lot of good plaintiff attorneys. Now the question is whether or not you can get your mindset into more of a neutral mode and call it like it is. And the other problem too is, too often, I would say 90% of the cases I get, discovery has already closed.
Okay.
And now it's time to hire the experts. And so they dump all these depositions and file materials on me. What do you think, Fred? I said, well, I think we got a problem. Again, this is just a shooting yourself in the foot thing. They should bring in the expert early.
Yeah. I think every expert says that, and even attorneys say that. Even attorneys would be like, hey, one thing we need to do better is bring in the experts early. But I think it's more of a lip service. And yeah, I get the money part. Nobody wants to
I'll give you a
spend
good
it.
example of one.
Mm-hmm.
This was a horrible case. I can't remember if he had already filed the lawsuit or was about to, but he was a plaintiff attorney, and it was a big exposure case involving environmental matters. And when he called me up on the phone, I was flabbergasted. Number one, the broker that he's suing is a very big broker, and I couldn't believe how they blew this. Number one, the guy handling the account for the brokerage was the executive vice president. That's what the insured thought too. Guy walks in the door, hi, I'm the executive vice president of this major insurance company, and I really want to work with you on your account. Oh, wow, you're taking away time from your corporate responsibilities. I'm so impressed, which of course wasn't true. That was the first thing I told the lawyer. I said he was the only way he got that title, because I guarantee you he's not a corporate officer. He got that title because he brings in $2 or $3 million a year in revenue, gross commission revenue and fee revenue. That's why he got that title. Really? And so I gave him a little crash course on how that works, so that he could use that in discovery to find out if that's correct. And then the mistake that was made here was that this is a big construction company, and they're going to be doing a big, tall building in downtown Los Angeles. What immediately comes to mind with excavation and built for a tall 50-story building or something? Environmental. They got half of what they needed. They got a policy that covered them for any pollution that they create, but they didn't get coverage for any pollution or unknown pollution that was already there and that they disturb. And that's what the claim was all about. Holy shit, that's some serious money. And I was like, how could they make a mistake like that? Number one, you want to find out this executive vice president, did he have any experience with environmental? And if he didn't, who is? Who is the expert? Number two, what carriers did they go to? Why did they use this carrier that only provided half the coverage? Why did they go to these other carriers that do? And the only thing I could think of, they don't have a direct relationship with them. Yeah. They'd have to go through a wholesale broker to get to these other carriers. But that means they'd have to give up some of the commission. and other stuff that, you know.
Mhm.
So over the course of 2 years, I had phone calls. That was it. And every time he would answer the questions that I was posing, they were exactly as I predicted. You're right. He's executive VP because he brings in all this revenue, but he was not a corporate officer. You're right. The expert, well, I'll leave that for last. And you're right. They dealt with carriers they have direct relationships with. They didn't have to go through a wholesaler, and on and on and on. And then I'll never forget this one conversation. He calls me up. He was so giddy, I thought he was drunk. But he's saying, "Oh my God, everything you predicted was correct. Everything you called every shot. You were right. The expert in Chicago is the environmental expert, but they're not allowed to do, to work with another branch office. Every office is its own profit center, and in addition, they have no way of sharing commission." And I just started laughing. I said, "Are you telling me that every decision that was made in this case by the broker was to enhance their own revenue, even if it was at the expense of the policyholder?" I said, "I think you've got grounds to go back into court and seek leave to amend and seek punitive damages." And 2 weeks later, I got a phone call. "What are you doing for lunch?" And I said, "It sounds like I'm having lunch with you. What's happened?" He says, "We settled the case. I can't tell you what it is because it's confidential, blah, blah, blah."
Yeah.
But I'm sure it was for millions. I had received a $3,500 retainer, and I had to give him a refund. My bill, I owed him $300. My bill was $3,200 for the time on the phone.
Oh, okay.
That was it. I didn't have, and I told him, I said, "You don't know how much money you saved, because if you were calling me today to see if I was available to go to trial, and you're going to dump 12 depositions on me and thousands of pages of documents, underwriting
Yeah.
file documents and emails and stuff like that, you're looking at $35,000 before trial.
Yeah.
You saved 90%, dude." That's phone calls are cheap.
Yeah.
10, 20 minutes, that's it. But cheap. 30 at my rate at that time, that was probably 6 hours worth of phone calls.
And today, do you have like a non-refundable retainer? Because that's a practice that a lot of experts want to. Yeah. What's your take on that?
Use it or use it kind of thing. I don't.
Okay.
I'm not going to speak for others. If I have to work for a living to live at my age, I got bigger problems. Yeah. I do this so I have a reason to get up in the morning, but I also don't work for free either, but
No, that's very well said. I mean, I think I was talking more from the point of view of the experts who are starting out. But in the insurance claims industry, as an expert witness in the insurance industry, what's the minimum experience one would need to have under their belt before they can hold themselves out as an expert witness?
I think that's pretty much true, about 5,000 hours minimum. And then it also depends, because, "Mr. Fisher, are you an expert in insurance?" Well, that's pretty broad. You want to narrow that a little bit?
Yeah.
I mean, there's some things I wouldn't be qualified to deal in, and I know that. I don't know. It even requires a special license to do railroad right-of-way coverages and reinsurance. I'm familiar with reinsurance. I'm familiar with the 3 different models of reinsurance. Have I ever negotiated a reinsurance treaty? No. Are they complicated? You better believe it. And there may be some couple of cases where, if it's obvious, I might be able to add value. There's a lot of areas of insurance that are really not qualified to deal with. And I'm not even, I mean, when you got 500 cyber liability policies out there today, maybe more than that, I don't know anybody that could say, "I'm an expert in cyber liability insurance." Oh, really? I don't know, because I used to read every policy we sold. How do you read 500 of them?
Yeah.
Really. And I understand the basics of cyber, actually more than the basics of cyber, but it is very complicated coverage. And the policy forms are getting more complicated is because the technology's gotten more complicated. And what used to be a 3 or 4 page application is now getting very detailed, because they're going into technical areas of security and stuff. I haven't got a clue what they're talking about. But what I do know is that if you don't fill out that application honestly, and you say you're doing something to prevent hacking or whatever, and you're not going to have coverage, because they're going to figure that out real fast and say you lied to us, and they're going to deny coverage, and that will be upheld. There's been plenty of that. So be honest about your area of expertise. Even lawyers' malpractice cases have handled so many as a claim guy, but to be an expert witness, I'm very careful about that one.
Yeah.
So sometimes they may take an actual licensed attorney, and there's just no way. But it depends. If it's something obvious like blowing a statute of limitations or something along those lines, and that's another matter. But do I think I've got the expertise to deal with a complicated tax structure or a major merger and acquisition kind of thing or problem? Depends on what the problem is. But I'm very honest about that. If I don't think I've got the knowledge, then I'm not going to go anywhere near it.
And this has been as eye-opening as it has been entertaining for me. I mean, I could actually go on for a few more hours talking to you about the insurance industry. Yeah, we definitely should. We definitely should do another one. But today, before I close this, I have a special question for you from Kevin Quinley. Kevin was the first guest on this podcast a couple of years ago when we started season 1. We are in season 3 now.
Well, he is been in the claim prevention side of things before me. So, like I said, I didn't invent it. Donald Malecki and Kevin's written 750 or more articles in this career. I'm thinking, Christ, I think I was doing good at 80.
Yeah, he's written a few for us as well. Like his articles are on our website too. So we reached out to Kevin and we asked him, and I told him that we'll be having you on the show for an interview. And he wants to ask you that what's your secret sauce for being so productive, that you have so many things going on, you have so many irons in the fire at the same time, and you seem to be doing great at all of them, and you're always busy, you're always doing so many things. So what is your secret sauce for being so productive?
I'm passionate about what I do. I love what it is. I love what I do. And I think I have the right message. And I think there are people out there that not only need to hear it, but there are actually people out there that want to. I mean, this is why we were so effective as an insurance broker. Our retail brokers knew we had their back, that we delivered. We were fixing policy language and getting endorsements before we even released the quote. So the retail brokers didn't even know that we had to get on the phone and say, we need this fixed. We just quote it. Sometimes we tell them, oh, we got some policy language fixed. Look at the sample endorsements attached. They knew we had that back. And they knew they were not going to get that kind of service from our competitors. And that was true. And that's what brought us in. We had a lot of retailers that did a lot of other types of insurance that we didn't do, like, big casualty packages and what have you. And so they go to another wholesaler for that. And that wholesaler might even have people there that did professional lines. And they'd say, hey, why are you using, Fisher's company? We can do that for you. He says, not the way they do. Mm-hmm. And that was the difference. And we heard that a lot. And that's where, like I said, our mantra was we provide financial security. Our competitor sells you some insurance. But when it comes to casualty stuff and commercial packages, that used to be, they're pretty standard. So were they as tricky as the stuff I'm dealing with? No. They've gotten that way. They're getting that way. But still, they found that a lot of wholesalers did not want to give them the advice, did not want to have it. They take this position, we're just a conduit. You send us an app, we send it to the markets, we get a quote, we send it out to you. Read the quote, read the whatever. And most of the time, they don't even send the policy forms. That was, like I said, 100% of the time. We send the form and the endorsements. We had our underwriters trained to send them to us. And yeah, we'd store copies. But do I really want on every quote to double check that my copy is up to date as the one they're just quoting now? No. was just easier to tell the underwriter to send me all the policy forms and the forms and the endorsements 100% of the time. We had them all trained to do that, and it worked very well. And for the most part, our retailers appreciated it. Did they read it? No, most of the time they didn't. But they were relying on us to cure any problems. And if we couldn't, we had a special disclosure in our quoting template, and it was in red. The typing was in red, so they wouldn't miss it. In addition, we even updated our agency management agreements with our retail brokers that put it in writing. If we make a special disclosure, you're obligated to pass it on to the insured. That way the insured can't say, oh, I didn't know. But, then the question is documenting it, by email, by fax, whatever. Noting a phone call in in your notes, I mean, that's been around since 1975. So, this is where Kevin and I started, right? Documentation was the key. For a long time, there's always been this rule that if it's not documented, it didn't happen. And that's been around since the 1970s. And so there you go. So did I answer Kevin's question?
Yeah, I totally did. So, Fred, thank you so much for being so generous with your time and insights.
My pleasure.
Yeah. And so for attorneys or anyone looking to connect with you, I believe we can find you at fishercg.com. But what's the best way to get in touch with you?
Well, my email address works. That's F as in Fred, J as in John, Fisher, Fisher, at fishercg.com. Or you can go to the website, the contact information's there. Pick up the phone. 310-426-2105. Remember the telephone? You can call me, and I'm usually around. And if I'm not tied up at a webinar where I've got do not disturb turned on, I'll take the call. But like I said, I'm not so jammed that I'm rarely in the office because I'm always in trial or in deposition or something. I don't need that kind of pressure. And I'm always willing to chat on the phone on a case, and I don't charge for the initial consult. And it's not hard. The real question is, do you want to hear? Somebody I think put on in a review or in a recommendation on LinkedIn, he tells you what you need to hear, not what you want to hear. Yeah. That's true. I tell you what you need to hear, not what you want to hear.
No, that's what I wanted to say as well, that if somebody's facing a complex professional liability matter, they know exactly who to call, but they need to be prepared for someone who won't sugarcoat anything.
Well, sure. And sometimes I've come up, and this is get your guy in early, because once discovery's closed, it's over. And there have been times I've come up with concepts or come up with stuff. They were like, oh my God, this is a game changer. I said, great. Do we have the evidence? This is no. Can we get it? Discovery's closed. But and there's a way of dealing with that, but still, it's makes it so much harder because the nuances are so important. And when somebody calls me on a new matter, especially for an insurance broker E&O case, and it doesn't matter whether it's for defense or plaintiff. While we're talking on the phone, I'm calling, bringing up the Department of Insurance website and looking at the licenses. Are they properly licensed? How do they have a bond? That they need to have, because in California you have to have a broker bond, $10,000 bond, and it's amazing how many times they don't. But then they may have the bond, but they may have had to renew it or change insurance companies, for instance, so they have to mail in the new one. But there's a $29 filing fee. And most people forgot that. So when they send in the bond without the filing fee, the Department of Insurance isn't going to do anything with it. And so you don't know whether they're bonded or not. One thing's for sure, as far as the bonding company is concerned, oh yeah, the premium's been paid, we have a bond. So are they in violation of the law? I don't know. The law requires they pay a $29 fee, otherwise the department isn't going to process it. But the bond's in force. So I don't know the answer. I don't know that anybody, I don't know that any courts had to deal with that. But I have to be careful. I can't say they're acting as a broker without a license. They don't have the bond. All I can do is tell the attorney, find out if they've got one, and tell them to mail it in with the $29 fee. But so you have that kind of thing. But that's another thing that's in my Insurance 101 class. And I always look up licenses. I look up law licenses,
Oh, yeah.
contractor licenses while
so
I'm on the phone.
Yeah.
Did they live up? How can you live up to the standard of care as I fill in the blank if you're not licensed as one?
Yeah.
So that's the kind of thing I do. It just comes from years of experience.
Yeah. No, I mean, like even in our expert witness background product that we have, where we vet experts and do due diligence on them, like one key aspect is to look at licenses, certifications, are they current? And another thing that we look for is disciplinary actions, like have, again, like where you can find the information. So, and a lot of times, like even with medical doctors, you would find that okay, they are like they have these certifications, but something expired a few months ago, and now they have either forgotten to renew it, but they are going to file a CV, or they have filed a CV in court in their Rule 26 disclosures that says that they carry out that license.
When we were in our claim adjusting days, from day one, when you meet with an insured, I was taught, get their background as well.
Yeah.
You know, have you done any lecturing, publishing, or teaching in the insurance industry? Oh, are they topics that deal with what we're dealing with here? Oh, really? Have you served on any boards of any professional organizations? For instance, do you serve on the ethics committee for the local, realtors, board, or that sort of thing? Oh, yes, you have. Oh, always ask those questions. 99% of the time, the answer is no. But at least we have an answer to the question. The last thing you want to do is find out at trial that this guy sits on 7 boards. He's written ethics. He's been involved in writing ethics. Ethical behavior for whatever association. He's done continuing education classes. He's written articles on the very topic we're dealing with here. He's going to be cross-examined with them. I mean, come on. I mean, I've been doing that my entire career since 1975. Yeah. So, but attorneys don't. Right? Attorneys don't ask those questions. They're like, how could you work in the blind like that? Have you talked to the client? Oh, yeah, we did before the deposition. So they get it. I mean, like, wait a minute. You mean to tell me you got an assignment from an insurance company to defend this insured? You haven't even talked to them? You don't even know their story? Oh, no, the claim file came. The claim guy sent us a copy of their file. Wow. Does it look complete? They don't even know what a complete file might even look at. How about the file notes? Because now that everything's automated with agency management systems, you can get an audit report. It's an audit report that shows you the date, time, and who did what in chronological order. And then if you're lucky, the system will it might be hot linked so you can actually see what was done. But at least you can see the timeline of all the activity on that file, or for maybe that policy, depends on the structure. But most attorneys don't even know that exists. A lot of trail. I have no idea. What was the activity on the claim file? I don't know. But this is something that the claim guy, we were used to getting this information from day one. That's what I say. We had the claim as factually developed in 90 days or less. And that was our goal. And we almost always hit it. And so, like I said, sometimes we even have cooperation from the plaintiff attorney to talk to their client. And we wouldn't waive anything. I mean, well, only if you waive deposition. Well, I can't do that. The real question is, do you want to settle a case early? Otherwise, we'll have no choice but refer it to counsel and take the deposition. But I waste time and money if it's going to be avoided. We wouldn't guarantee a settlement, but at least we got a better chance that, okay, I've heard what I need to hear. And we've got documents and whatever, and we talk to the carrier and whatever. But it's always, what's the best way of getting out? What's the best way of closing the file? I always felt, I don't want a good lawyer. Good lawyers are a dime a dozen. To me, my definition of a good lawyer is he knows the law, he knows discovery, he knows civil procedure, he knows how to try a case. Lots of them. I don't want a good lawyer. I want a good problem solver. Yeah. To me, cases in suit is a problem. How do we solve it? And so I always look for a good problem solver, and that's a lot harder to find. And I had quite a stable of good problem solvers, so that when we were TPAs and we had assignment authority, I would do my best to get the lawyers we really liked, who were really good problem solvers. We would do our best to get them on our approved list by the insurance company, and we tell them why. And we tended to stay away from the big chains, because those are just factories. And I won't mention names. And I also don't want to draw a broad brush, because there's a couple of chains that I know of that are really focused on settling cases. There are those firms. Problem is getting them. But unfortunately, and I've written attorney management guidelines at the TPA. I had to get them approved, of course, but still, we've authored attorney management guidelines. I've seen some attorney management guidelines from some carriers. They were strangling their defense lawyers. I'm surprised they could go to the restroom without having to call and get permission. Seriously. I mean, and that's counterproductive.
Anyhow, thank you so much, Fred, for your time.
Oh, been pleasure.
This was a lovely conversation. Very useful, very enlightening and insightful. So I'm pretty sure the audience will love that. The attorneys, and especially I'm looking forward to sending this to all the plaintiff attorneys and the defense attorneys on our network. And I believe they were like excellent insights on both sides of the bar here. So thank you so much once again, and I definitely look forward to doing this one more time, at least one more time.
Well, I'm at your disposal, because I mean, it changes so rapidly. One of the things about the professional liability industry that I've said many times, our world can get turned upside down by the simple stroke of an appellate court pen. And then the other half of that is, and plus gets it out there faster than anybody. There's your commercial for the Professional Liability Underwriting Society. By the way, they are now no fee membership. You can join Plus, and there's no fee to join. Fantastic organization. Thank you so much. This has been a pleasure, Ashish, and I'm sorry to take more time than you normally would allow, but it's always fun. And of course, I'll be happy to chat with you again. So thank you.
Thank you so much.